And I'm going to record today because I'm going to go a little bit off script based on some of the current things that are going on. We're still going to be talking about purchase contract scenarios, and we're going to go over a lot of the same scenarios, but every time I do these, I've picked these scenarios because these are ones that commonly come up amongst the agents in my office. And so we're dealing with these types of things all the time. And the scenarios themselves are very contrived. If you've been with me before, you've seen them. They're not stuff that you would run into, but they're built that way to teach the lesson. Okay. So with that said, we still got a few people jumping in. So with that said, don't sit there and think, well, this would never happen. You know, this is silly. Why are we even talking about this stuff? It's the lesson behind it that we're trying to get. And sometimes we use an extreme example to teach the lesson. So I'm going to go ahead and start sharing the screen. And by the way, I'll take a chance to introduce myself. I'm Eric Lee, the principal broker for Equity Real Estate here in Utah. And I do realize that we have agents from all over the country that are on here. This is the one training that I do where we go into more specific Utah law. So if you're in a different state with different rules and laws, hopefully some of the things that I talk about today, we're going to get into some of the details with the contract. Now we're going to be talking about the Utah contract, and we're going to be bringing up Utah law. I don't want to lose you in this discussion. What I want you to do is question the details of what you know about your law. I want to encourage you, if you're in a different state and this raises some questions in your mind, to have a discussion with your managing broker. You know, are things the same here? Or maybe learn where you can yourself go in and research law in your own state. For most of us, the only time we ever look at Utah law was when we first got our real estate license and we went through some mandatory education requirements. Beyond that, we don't really get a lot of Utah or state law, rather, as a part of our CE. You know, we had CE in our office the other day and they had technical difficulties, so it got canceled. But it was on trusts and it was title companies. We have lending things, but we don't really get a lot of CE based on Utah law. So we are going to be diving in a little bit more into that today. So if you're from another state, again, this I believe will still be relevant to our discussion. And a few of the things that our laws are federal things that we'll be able to hopefully create some value for you. All right. With that said, as we get started, I've introduced myself. If you have questions, comments, feedback, you can email me directly at brokerericlee@gmail.com if there's other things you'd like to see training on. I've also got my YouTube channel. I would encourage you to go to and subscribe to that. That's where I keep recordings of past trainings. And like today, I'm doing an updated version based on current events. So that's why I'm recording this, and I'll store it there. And if you are anxious to learn more and this 1 hour a week isn't sufficient for you, then I've created an online training course at eliteagenttraining.com that you can check out. So those are some of the resources. All right, let's dive into our first scenario. And these are questions and answer scenarios. I'll share the scenario with you. I'll go back to our full screen where we can see everybody, but I do want you to participate, okay? And so you can raise your hand. If I can see you, you can raise your hand. If not, then if you go down to your Zoom panel, then there is an option down there for, let's see, where is it? Boy, they've added a whole bunch of new things. Oh, there's a one called reactions. Okay, so you can click that and you can raise your hand in that way as well. Let's look at that. Yeah. Okay, so here's our first scenario. Whether or not we have acceptance. Brad makes an offer to purchase Sue's property. Sue gets the offer, decides to counter it. She gives Brad until October 31st at 5 p.m. to accept the counter offer. And suppose that Sue is aware that there might be some other people that are interested in the property. So at 4 o'clock, 1 hour prior to his deadline, Brad decides to accept the offer. He signs the contract and he decides he's going to hand deliver it. This is where it's contrived, but maybe he lives down the street from Sue and he wants to hand deliver it. So Sue's sitting in her front room. She sees Brad walking up the driveway, and Sue, because she has been working the phones, she thinks she's going to get a better offer. And so she wants to revoke this. So Brad rings the doorbell and Sue yells through the screen door, "I revoke my counteroffer." And Brad replies, "But I've accepted your counteroffer. Here's the signed contract. Is there a contract here?" Now, a lot of you have been through this scenario before, so you know the answer. What I want to discuss are the lessons that we can learn from this, okay? So the first lesson, and for this, I'm going to stop sharing the screen so that we can all look at each other and see how we're all voting. Brad has till October 31st at 5 p.m. to accept this offer, right? Can he take till 5 p.m. to accept it? Is that like a guaranteed time slot for him? Or if the seller receives another offer prior to that time, can they just accept another offer and cut Brad out entirely? Because I've had some interesting interactions with, I call them the good old boys. People have been around for a long time. They're like, you know what? You were here first. I honor my word. You know, what do you guys think about that? Brad was there first. He got his offer in. They gave him till Halloween at 5 p.m. But the day before, somebody else brings in a better offer. Does that listing agent honor their word and give Brad till Halloween at 5 p.m.?
I think they would just need to tell him, hey, we accepted something else. I don't know. I don't know the right answer.
And Brad's like, but you gave me till 5 p.m. I still have the right to accept this.
It's tricky.
What do you think?
I'm not sure.
No, I mean, they have a right to accept whatever offer, whoever signs first, right?
Yeah.
5 p.m. is the deadline where that would be no good after that if they don't sign it. But it doesn't matter who signs it at what time, or you tell them. It's who's ever first, and they have a right to do whatever they want first.
Yeah. And so I'm going to try to make these scenarios tricky, Denise. First of all, I do appreciate you speaking out. I'm trying to make them tricky on purpose, but they shouldn't be. Okay. The goal of this exercise today is for all of us to just understand how the contracts work. And if you don't, and again, you're from a different state, then I want you to dive into your contracts and read the details. Okay. You could pull them up during this training right now. So I'm going to share a different screen with you right now. Let's see here. We are going to go to the Utah real estate purchase contract. All right. And the part that we're going to go down to is acceptance. So in each of your contracts, if you're from a different state, check out your contract. What is defined by acceptance? Because it is defined in the contract. So acceptance occurs only when all of the following have occurred. Okay. Only and all are both emboldened here. So the seller or buyer has to sign the offer or counteroffer where noted to indicate acceptance. And the seller, buyer, or their agent has to have communicated to the other party that the offer or counteroffer was signed. So knowing this, let me go back and share our scenario. All right. Did the things to accept this, like if we're making an argument, because Brad could come back later on and make the argument, hey, we're already under contract. I've already signed it. You gave me till 5 p.m. I've signed it. I was just coming over as a courtesy to give it to you, but we're already under contract. You can't accept another offer. Would Brad be correct? He's already signed it.
No, Brad signed it, but he didn't communicate it.
Okay. And so when we, sorry, I'm going to mute you, Rachel, because I'm getting an echo there. Don't know if that's on your end or mine, but you're welcome to unmute yourself again to talk. But Rachel is totally correct. Two things had to occur because it was only when all of those things had occurred. We need to have signed it and it needs to be communicated. So question here, what if I'm the, let's see, what if I'm the buyer's agent? Okay. And the listing agent has countered us. And so I'm sitting with my buyers and we're sitting at their kitchen table at 4 p.m. on October 31st. And Brad, my buyer, signs the purchase contract. And I call up Sue or I text Sue and I say, we're under contract. We just signed. Is that true?
Yes, sorry, my oven's on in the back. Yes, you're under contract. I had this situation yesterday. So my buyer had signed, and then I was with other clients and I got a phone call from him. So I actually held off on communicating that we had signed their counter to see whatever he wanted in the phone call. Cause I was like, I don't want to communicate that we're under contract if he's all of a sudden like, nope, I don't want to I want to unsign basically. So signed and communicated.
Okay. So if I've texted, is that communication?
Yes, they don't have to have a copy of the contract.
Okay.
I don't think it would be communication because they haven't, you don't know if they've received it
Yeah. What
and
if they didn't get
acknowledged it. Huh?
Exactly. So here we're getting into the weeds, but this is exactly what attorneys do. Okay, they get into the weeds. And so if we go back to our contract, attorneys are going to be arguing, does sending a text constitute communication? Because communication, shouldn't that be two-way? Like what if I had signed it and emailed it? Is that communication? What if I've signed it and faxed it? Let's go real old school. I've signed it and faxed it. They have a physical copy sitting there on their fax machine. Have we communicated it?
I don't think so, because whenever I have signed a document and tried to get back with agents, I will say, please let me know that you have received this at the end, and I'll email it and text it. And until I receive confirmation that they have received it and that they're accepting that as their confirmation, then I don't believe that we're under contract yet.
Yeah, so this little bit of language right here is the key thing to understand. Okay, what would a judge or an attorney deem as communication? We've actually talked about this in our next scenario here, but the safest way to go isn't to just rely on a text sent, a voicemail left, a fax sitting on their fax machine, or an email sent. None of that constitutes communication. Communication would be some two-way thing. So if I am sitting at the kitchen table and I text and say, hey, my buyer's just signed, we're under contract, looking forward to working with you, please acknowledge that you received this text ASAP. And if they respond and say, got it, have we communicated now?
Yes. Now
Yeah.
that they've given you a thumbs up or they've communicated back, that means yes.
Yeah, now there should be no question at all, right? And we've got timestamps on that text chain and everything. But hold on a minute. I haven't actually given them the contract. Okay. So, I mean, yeah, we signed it. We're sitting at the kitchen table, but they don't have the contract. Can I say, I'll get you the contract tomorrow morning? What if I don't get them the contract tomorrow morning? What if, it slips my mind? What if I'm sick? I get COVID tomorrow morning. Boom. I'm out for a few days.
I don't think they have to see it. It's signed and communicated, and you have the timestamp on it when they signed, and the either phone call or text thread of when it was communicated and acknowledged.
Yeah. Isn't that interesting though? Signed and communicated, it doesn't have to be received. It doesn't have to be delivered. Now, I do want you to notice, I'm going to go back to sharing the screen here. I do want you to notice that different things require different things, okay? So if we go to notices here, except as provided in section 23, which is acceptance, all notices must be in writing, signed by the client, and received. Isn't that interesting? So all your other notices required by the contract, they do need to be received. They need to be in writing, signed, and received by the other party. But acceptance doesn't. So again, if you're from a different state, you're going to probably have different language. Do you know exactly what that language means? Because these details are the bread and butter of attorneys when attorneys get involved. All right. So that is our first scenario. We've had a good discussion on it. Hopefully you guys I guess my goal of this whole thing today is to encourage you to really get in and know your contracts. It's not enough to have skimmed through it with what you had in real estate school. That's not providing enough value. Because if we're giving our clients bad advice because we don't know our own contracts, we're not providing the value that is worth the commission that you're getting paid. Is a real estate agent worth their commission? Absolutely, if you're worth it. Because I can't just say a real estate agent is worth their commission. There's a very good chance you're not. That is something that takes work and effort for you. Can you be worth your commission? Absolutely. In every single scenario out there, a real estate agent could be worth their commission if they're providing this value that comes through extra training. All right. So anyways, there's this scenario, this idea that they could yell through the screen door and say, I revoke my counteroffer. Yeah, it actually could work. It poses an interesting legal question. And it says down here, that the offerer could see the approach of the offeree. They could see it on their caller ID. Oh, so-and-so's calling. They could answer instead of saying, hello, this is Eric. They could say, I revoke my counteroffer. Makes some interesting scenarios, right? So the risk reduction tip here is obviously if somebody did that, there's going to be an argument. We've had even different viewpoints here just with our group. And some people saying, yeah, I think we're under contract, and others saying not. And well, Brad says, well, I yelled it through the screen door before she did. And now we've got he said, she said, and that gets really ugly if you go to court and stuff. So the best thing to do is do these things in writing, right? If we've got a text, we can do a phone call, but a phone call is hard to show that we had the interaction. So a text is great because we can communicate that. I did have an old school broker. This was, I don't know, maybe 10 years ago, giving a training at a different board. And he's like, we need to get back to the basics and hand deliver stuff. And I'm looking at my agents like, no, it is really hard to prove hand delivery at a certain time. Like technology can be very good for us in certain ways. And this is one of them. It's one of the reasons I like .loop, because I've got a date and timestamp on that. And by the way, if you're wondering, do attorneys really get this nitpicky? I've had attorneys arguing about the 5 p.m. because our contracts say everything has to be done by 5 p.m. They've argued over because they've got the timestamp on the computer and it was 4:59. And the argument was, how do we know that computer was synced to the atomic clock in Denver? That's how detailed attorneys can get. All right. So pay attention to those details. All right. We've got a multiple offer one. One of our agents actually texted in on that last one. Hey, if you did get a multiple offer, wouldn't you be using different paperwork? So for example, Troy had said, if this offer had been countered and another offer comes in, could we just accept that other offer? And Troy correctly said, yeah, you could. They don't have this guaranteed time slot until October 31st at 5 p.m. to accept it. So if I got another offer that was higher, I could just accept that offer. Here's the problem. What about that other offer that's out? Like I already countered one, so I really like number 2 and I want to accept it. What about that one that's floating out there still? And that's what this scenario talks about. So buyer number 1 makes the offer to purchase the property and seller counters it with an increased purchase price. Then buyer number 2 comes along. We really like this one. So we sign it, we sign the contract and we communicate acceptance. All right, signed and communicated. There we go. Now, minutes after the seller communicates their acceptance to buyer number 2, buyer number 1 sends over their signed acceptance of the initial counteroffer. All right. Now, both buyer number 1 and 2 feel like they have a contract with the seller. And let's just say that buyer number 2, when they faxed it over, they also, they wouldn't even need to necessarily communicate it, because if the seller calls them back and says, hey, we got your faxed counteroffer here, or we got your faxed acceptance, we want to let you know that we already accepted something from somebody else. Now, if they're saying they got the faxed acceptance, it's been communicated, right? That would be my argument. So who has the valid contract here? Buyer number 1, they were in position first. Buyer number 2 was under contract first. But buyer number 1 also feels like they have a valid contract. Who's right?
I guess whoever records first.
Okay. No,
No.
it's not a race to
Record
the finish.
quick.
It's not a race to the finish. Who can, file a notice of interest on the property or something like that. That's not what we've got here. What we have is actually two different parties that have both fulfilled the terms in the contract for acceptance. They've both signed and communicated acceptance, which means seller's obligated to sell the property 2 times. Can he do that? No, can't do that. So he's got to break one of the contracts. That's a breach. And what is the penalty for breach?
Earnest money returned, and then also they can either give that amount of earnest money back to them for the breach of contract or get sued.
So we've got 3 different penalties, at least in our contract, and who gets to choose which penalty is applied? Because this is something that came up with a very prominent broker. I think it was just last week. A very prominent local broker was arguing with one of my newer agents, and my newer agent had attended this class, and she's like, I don't think he's right. And I'm like, I love it when my brand new agents can stand up to a prominent broker who is wrong, right? And the lesson that I take from that, by the way, isn't that, hey, we're better than you are. It's, hey, all you guys out there that aren't continually studying your forms, because this is a prominent broker, they know their business, they're really sharp, but time marches on. Forms change, contracts change, laws get amended. It's very easy to leave your knowledge in the dust and be operating off of old, archaic information that's no longer relevant. Okay. So this is something that just happened last week. Who gets to pick the penalties?
Be the damaged party. Well, I don't know. I guess it depends on who's.
Yeah, so here we've got the default section. If the buyer defaults, seller can elect.
Right.
If seller defaults, the buyer can elect. And there's 3 different remedies, and we need to know what those remedies are, right? So that we can advise our clients correctly. And I have had agents that have been under contract with 2 different people. Both buyers called attorneys. I called an attorney. Everybody's getting attorneys. And thankfully, these attorneys weren't the stereotypical ones that are just trying to drive up the billing. They both advised their client, because it was the same day. And even though it wasn't minutes apart, it was hours apart that they had gone under contract. The listing agent, when they went under contract with the first one, they did not immediately call and revoke their counteroffer. They didn't put it in writing. Now, again, it's a notice, so it needs to be in writing, but you want to communicate that as well right away. So I would say do it in writing, get it signed by your client, the revocation, send it over, call, text, so that you've got a paper trail, right? You want that paper trail. And in our scenario, both attorneys advised their clients, thankfully, that nobody had experienced actual damages yet. It was day 1. They'd just barely gone under contract, so you could sue for actual damages. It says other remedies available at law. Usually that's damages. What about suing for performance? Can we force them to sell to us? And both attorneys you don't really have any better claim than the other person. Whether you went under contract a couple hours earlier than the other one is irrelevant. Both legally, according to the terms of the contract, have a valid contract. It doesn't matter who came first. So both attorneys advised their clients and said, it's a default, and probably the best thing for you to do is you get your earnest money back and an equivalent amount in liquidated damages, and just move on with your life. You're out a couple hours of time and you made $1,000, Now, this is risky if you're the listing agent and they've put $10,000 down in earnest money. One of the UAR attorneys said the highest that he saw over the craziness in 2020 and 2021 was $1 million in earnest money. That's not the contract you'd break, is it? you pick the one with $1,000. And that's what they did. They picked the one with $1,000. The agent actually paid that out of his pocket rather than have his client pay it, because the agent should have known better. I mean, that's why they were hired, right? And I actually agree with that. I think the agent should have provided that value of knowing how to navigate a multiple offer scenario. Now, guys, when we're talking and we're looking at some of the current legal scenario, if you're tracking this NAR lawsuit in Missouri and stuff, one of the biggest challenges that we need to rise to as a result of this is being better at not only creating value, but communicating that value. And so knowing how to handle a multiple offer scenario, right there alone, that one thing, you could be worth more than your commissions, knowing how to properly handle that. But if you don't know your forms, and here we're just talking about how the basic purchase contract is handled, and yes, we could get into the weeds with the different multiple offer scenario forms, but not knowing your tools that you have and giving your client some bad advice where it could be a breach of contract. And it is not uncommon. I mean, it's almost uncommon to see $1,000 earnest money anymore. Seems like 5, 10, 20. That seems much more common these days. And if you're costing your client that kind of money, that's a tough pill to swallow, right? You haven't provided your value. So know your value and communicate your value. That means if you're a listing agent, you're sitting down, you're talking. When you do these things, when you're solving these problems for your client, take a moment and say, this is why we're using this form. This is why we're doing this. Because if we didn't handle it this way, then these are the bad things that could happen to you. When you get to the end of that transaction, every client out there should be a raving fan of realtors. They should be like, I don't know why I ever thought I could do this myself. I've had agents join me and, you know, this wasn't their first career. They've done other things. And they're like, I don't know why anybody wouldn't sell their home themselves. I sold 3 or 4 homes as a for sale by owner. It was easy. And I said, come back to me in 6 months and tell me what you think. And after 6 months, of course, he had seen just a variety of problems and challenges that people run into and encounter. And he came back and he said, I think I know why I didn't have any more problems. I think I probably sold for way less than I could have. And nobody wanted to raise an issue with the inspection or the appraisal because they didn't want me to know. Like everybody else knew that I was giving the house away for 10% below market value. Everybody else knew except me. And that's why everything went so smoothly. So have these conversations with your clients. Let's go back to our scenario. All right. So again, we've talked about that one. Who's got to sign the purchase contract for it to be valid against the sellers? This is a really simple one, but it does come up occasionally. And I'm not going to get into the weeds on this one because I want to get into the weeds on another one coming up. Okay, but let's go over this really quickly. We go under contract and again, another scenario where a backup offer comes in and the seller wants to cancel the first contract and accept the backup one. And her agent says, hey, you can't do that. And then the seller says, hey, but my husband never signed the listing or the purchase contract. So is this enforceable? What are the questions we should be asking here?
Who's the owner of the home? Like who's on title?
Yep. Not only who's on title, but how are they on title?
Yeah.
Right? Because there are forms of title where one person can sell their interest. But typically, if it's a married couple, one can't make that decision on their own without the other one. So do we even have a valid listing agreement? No, we don't even have a valid listing agreement, let alone a valid contract, right? Both have to sign it. So there's easy ways to avoid this. But again, this is where real estate agents can provide value because a lot of people don't know this. Do y'all know somebody with a home in a trust? Who needs to sign it? Do they know?
The trust, whoever's in charge of signing for the trust can sign for it.
Trustee.
So we need a copy of that trust, right?
Right. Copy of the trust.
Title company's going to need a copy of the trust at closing. Sometimes these trustees, they don't know how it works. Somebody set it up for them. They're not sure who needs to sign it. Okay. What about now military? Typically, they're pretty well trained. When somebody goes off on active duty, they're pretty well trained, at least every time. And I used to deal with them a lot. They're pretty well trained on powers of attorney and stuff. But what about divorce scenarios? This comes up quite often, right? You get called to help somebody out. They're going through a divorce. You've got an appointment to meet with one of them. If you check title beforehand and you see 2 names on title, you call them up and say, okay, I see 2 names on title. Will your husband be there? Oh, we're actually separated right now. We're going through a divorce. And so, no, you're just meeting with me. Is that okay? Can I
I
just,
think you'd need to set up a time when they could both meet because they're both on title, or I don't know, what if,
they
what
hate
if,
each
what if
other's
it was a
guts?
situation?
This isn't
where-
a friendly divorce.
Yeah, what
This
if it's
is
not
one where
friendly?
they hate each other, and maybe there's a restraining order in place even. What can we do?
That's tricky.
Have to meet at separate times. Have to meet at separate times, but they have to unanimously agree that they're both on the title regardless.
Yeah, so we could meet them at separate
Even
times.
if there's a,
Yeah, that's a good solution. We could meet at separate times. Another one is Zoom. Okay, you don't have to be in the same room together, but it is very important that you both know that I have an obligation with my, we call it fiduciary duty. I have an obligation to disclose everything to both of you. That's easiest done if I'm not having separate meetings with each of you. Okay, we can stay professional. You can keep yourself muted, but this way everybody knows that anything shared with me is also shared with the other party. You can't tell secrets to me and not have me tell it to the other party. Okay, I've got a fiduciary duty to both of you to be completely open with both of you. Have you ever heard the line, oh, I have rights to sell though? I have the right to say, yes, my husband's on the property, but I have the right to sell it by myself. What do we need? What gives you that right?
Need a copy of the divorce decree or the separation agreement.
Exactly. And it needs to be signed by the judge,
Mhm.
right? Because even if we come to an amicable agreement, we turn that into the courts and the judge signs it. Right? So I need a copy of the divorce decree signed by the judge saying that you're the only one that needs to sign this paperwork. And even though you're both on title, if I have that signed by a judge, I'm good to go. Title company's going to need that at closing too, right? They're going to look at title and see both names on there. So all of this stuff that comes up in this scenario is handled with us doing a little bit of work prior to. So it's really easy to check the title report prior to going out to that listing appointment. It's really easy to ask the question, okay, I see 2 people on title. Are you both going to be there? Okay, why not? Okay, great. Then I'm going to need a copy of this divorce decree. I'm going to need a copy of the trust, whatever, right? And again, something that a professional can do that a regular person doesn't do. They don't know these things. This is where we provide our value. Okay, so that's that scenario. Conflict between what's posted on the MLS and the purchase contract. Now, I haven't seen this in a long time. It used to be very common that we would write in under the included items section as per MLS. Is there a problem with that? Can I just write as per MLS on what's included and what's excluded? What's the problem with that?
well, I think that it's not, the MLS is not the contract. It's just listing information.
Yeah. So am I going to say, see attachment A per MLS? That's kind of dangerous, isn't it? Because at the bottom of every MLS listing, it says information deemed reliable, but not guaranteed. Right. So if I'm making the MLS an actual attachment to the contract, that creates its own set of dangers. So I never want to just say as per MLS. Don't be lazy. Take the time to fill it out. I'm going to share my screen here with you, though. We're going to go back to the purchase contract up at the top where we talk about included items. Now, again, this is the Utah contract. So if I fill it out from the MLS, it's going to autofill. Refrigerators, washer, dryer, and shutters, right? Because that's what, when I put it onto the MLS, these are the things that I mentioned were included items. So it's going to autofill these things as I fill it out. Does this create a problem? Potentially it does. It creates a problem with an underwriter, right? Is an underwriter lending on personal property or real property? The bank. They're lending on real property. They don't want to see a ton of personal property here. I've seen cars. I've seen a dog put in the purchase contract. Hey, we love that yellow lab. And the person's like, that was my ex's. You're welcome to it. You know, is lender lending on a yellow lab? No, they're not. So they're going to come back. If we put a lot of this stuff in here, they're going to come back later on and say, you have to give us an addendum removing all of this personal property. So it's going to create some issues, right? Here's the other problem with this is, what if I check a box, washer, dryer, and fridge right there, and deleted all of this? Do lenders have problems with that? No, they don't. They don't. So if I'm including some things, if I do this, now what about the shutters? Shutters aren't checked here. Can they take their expensive plantation shutters now? Because I forgot to type it in.
Aren't they attached to the building though, theoretically, or?
Yeah, they are.
Which shutters are pertinent to the property?
What was that, Troy?
Those shutters are permanent to the property, right?
Yeah, they are. They are. So do we need to have buyers and sellers that understand real estate law and this rule of attachments and fixtures and all of that? Or do we just need to make sure that we know what's written up here?
You need to know it.
Okay. So if it's written up here, do I need to write it again down here? No, I don't. I need to pay attention to this stuff. Right? Guys, we're not just going down looking for blanks to fill in. That's what your clients would do if they were representing themselves. They would look for blanks to fill in. We know better. All right. We don't need to mention that the range is included. It's already mentioned right here. Okay. So be aware of that kind of thing. Now, what if there is a bunch of stuff included and we know it's going to trigger an underwriter? Like, what if I'm selling a fully furnished townhome? We get that all the time up in, resort areas. I've got a whole list of things, right, that's going to be included in it. So what can I do? Well, I've got this little section down here. That the above checked items shall be conveyed to buyer under separate bill of sale, right? In addition to any boxes checked in section 1.2, there are additional items of personal property that we intend to acquire from seller at closing by separate written agreement. Now, could the underwriter say, hey, you mentioned a separate written agreement. I want to see a copy of that. Sure, they could. They don't usually, but it is a separate agreement. And we've mentioned the separate agreement here. So it's not constituting loan fraud that says, hey, we've got a separate agreement for the personal property. And there is a separate form for that. We can fill out the whole list of stuff that's included. Okay, I am getting off topic here. Let's get back to our scenarios. The point here is, know what's included in the contract. Don't be lazy and ever write as per MLS. Don't include the MLS as an attachment. All of those things can create conflicts. All right, is a seller property condition disclosure form necessary for an as-is sell? We've clearly posted it's as is. You're representing an investor. He buys and flips property. Okay, this is what he does. Buys and flips. And he just says, it's as is. I've never lived there. What do you think? Do we need to include disclosures?
Yes.
I think it still needs to, yeah.
But I've never lived there.
Then he needs to mark
Doesn't
the
matter, then tell you what you know.
And
Oh.
if he was sold by someone, they would have disclosed stuff to him when it was sold to him.
Yeah. You guys are all correct. Do flippers have information about a property, whether they've lived there or not?
Yes, flippers do.
Yeah,
Because
sometimes they have more
they're
than somebody that lived
remodeling
there.
it.
Yeah, sometimes they have more info than somebody lived there for 20 years. So this time I'm going to share with you state law. We're going lots of places today. Okay, this is from the Utah Office of Administrative Rules. There's the law right there. These are affirmative duties required of licensed agents. And this is talking about fiduciary duty. Okay. One of those is confidentiality. Prohibits the agent from disclosing without permission any information given to the agent by the principal that would likely weaken the principal's bargaining position if it were known. All right. So if we go back here to our scenario, does that change anybody's mind? Like, hey, if I disclose some of this stuff, then that could actually weaken our position.
No, because anything on the property has to be disclosed. Anything that is a defect or anything known by the owner needs to be disclosed by the property.
Okay, Jennifer, but what if I don't hire an agent? Then I don't have to disclose it, right?
You still have to disclose it even if you don't hire an agent. Because it's in
No,
Utah
I think
law.
you do.
Okay, this is actually something that I've heard from people. All right. I've heard people say, I don't want to hire an agent because then I have to disclose things. Guys, the law applies to everybody. There is not a specific set of laws that just applies in case a real estate agent is involved.
That's why you hire an agent so that you don't get in trouble with not disclosing things. They tell you, hey, disclose.
Exactly. Here is another way that you create value for your clients. There's that stain on the ceiling. Oh, we'll just paint it. Nobody will know. That's fraud. Okay. If you're involved, you can tell them that's fraudulent. We know of it. We have to disclose it. Right? Oh, well, we fixed the leak. So now we don't have to we fix the leak. We'll just paint it. We don't have to disclose it. Not true. Okay. The seller disclosures say, have there ever, do you know of any problems in the past? So if we go down here to that last little bit, so we have an expectation of confidentiality, accepting any known material facts. So if there's material issues, now, by the way, this is defects in the property or client's ability to perform on the contract. So let's say, for example, that I'm the buyer's agent and we turned in our earnest money and the check bounced. Okay, we got 4 days according to our contract here in Utah to get earnest money turned in. We turn it in, we're notified the next day, check bounced. Do we keep that confidential? We call our client, we're like, hey, your check bounced. They're like, oh crap, I just got paid. I thought I'd have the money in my account, but I just barely got paid. I'll get it deposited. We'll get a new check deposited today. We'll be good. It's day 5.
You still have to disclose to the other party, say, hey, this is what happened. And see if they'll still work with you and move forward.
Yeah.
At the end of the day,
Yeah, if you want any chance of saving it, then yeah.
I mean, at the end of the day, full disclosure on everything, and communication is never going to hurt you. And so you just need to just communicate it.
Yeah. What happens though if I've got 4 days to get the earnest money turned in. I get it turned in on day 1. I'm Johnny on the spot. Boom. Got it. We're under contract. Let's go. Get the earnest money. We turn it in. Day 2, we get the call. Hey, that check bounced. Call our clients. They're like, ah, crap. Sorry, just got paid. I'll get the money in the account. We'll get you a new check tomorrow. Day 3, I get a new check. Day 4, earnest money cleared. Do I need to let anybody know?
No.
Day 2.
No, because you're still within your contract period of putting that in.
Yeah, I complied. Okay, my ability to perform on the contract is not in question. So when I go back to that Utah law, the client's ability to perform on the contract, I performed. I'm good. If I didn't perform, I can't hide that. That is now a material fact. Okay? Does that make sense? That's why it's always good, even though the contract says you have 4 days to turn it in, get it done on day 1. You had till October 31st at 5 p.m. to sign that contract. What if you'd signed acceptance on October 28th? As soon as you got that counteroffer, boom, let's go. Let's get on it. Let's meet. Let's get this signed. because it takes away Sue Yu's ability, this other agent, takes away her ability to go out and work the phones for 3 days trying to get a competing offer against you. Okay, because that counteroffer says you have until this date at 5 p.m. doesn't mean you really have until that date at 5 p.m. Somebody else could come in. You know, just because you have 4 days to get earnest money turned in doesn't mean that always works. They get it turned in on day 4 and the check bounced. Technically, that's a breach of contract, right? You did not perform according to the contract. So let's go back to our scenarios. Hope you guys are having fun with this. Let's see. Stigmatized property statute. I'm not going to get into this one because there's one that I want to play with more. Not that one. Not that one. Not that one. This one. Yay. Lead-based paint addendums, disclosures, and pamphlets. I want to look at you guys in the eye. We're going to vote. Got a home built 1979. I'm the listing agent. Do I advise my client to provide the lead-based paint addendum?
1978 and older, right?
Okay, that's my next question. Let's say it's built in 1978. Now, do I need to provide it?
Yes. I don't know. Wait, does that say older than 1978? Now I don't remember.
No,
and by the
because
way,
it's
this is
before.
federal. This is federal, so this doesn't vary state by state. What is it?
Before 78, so 1978 isn't included.
Prior to 1978. I need the lead. So prior to 1978, in homes built 1975. Do I need the lead-based paint addendum?
Yes.
I tricked y'all. Okay, I'm going to share my screen. And this is where details matter because clients don't know this stuff either. All right. And you guys do know this, but I'm tricking you on purpose. So let's go and look at our forms. Lead-based paint addendum. That's what I said. Built in 75. Do we need a lead-based paint addendum? Don't know. Don't know. What does it depend on? Lead-based paint disclosure. The lead-based paint disclosure is required on every property built prior to 1978. Do I still need a lead-based paint addendum? Maybe, maybe not. Right? How do we know? This is something every one of you should know perfectly right off.
If it has lead-based paint, if lead-based paint has been found?
No,
No?
no, that's not it. How do I know when a lead-based paint addendum is required?
If they want to dig more into it and have an inspection specific to that.
Let's go down here and look. If I check this box right here, they only get to initial 1. They get a 10-day opportunity to conduct a risk assessment or inspection for the presence of lead-based paint or lead-based paint hazards. If this box is initialed, the REPC must include the lead-based paint addendum. Or they check this other box that says they waive the opportunity to conduct a risk assessment. All right. If they've checked this box, they get this extra 10 days to do their risk assessment. The lead-based paint addendum must be included. So let's say that they said, no, we're not going to do a lead-based paint assessment. We're comfortable with lead-based paint. There's no chipping paint. We're going to repaint everything over it anyways, which is typically the remedy for lead-based paint is just paint over it, right? It's not off-gassing into the air. So they're just going to paint over it. They're not worried about it. They're not going to do a risk assessment. Does any of this apply? Number 1.1, buyer's obligation is conditioned upon the approval of risk assessment. Well, we're not doing a risk assessment. That doesn't apply. 1.2, the risk assessment of the property shall be paid for by the buyer. Well, that doesn't apply. Guys, none of this applies. And yet I've seen agents include this in there, and then an underwriter sees it and says, we want a copy of the lead-based paint risk assessment. Oh, we didn't do one. You said you're going to do one. You've got the addendum in here saying you're going to do one. I want to see a copy of lead-based paint risk assessment or you don't get a loan. Has the agent that marked this wrong, that included a lead-based paint addendum rather than a lead-based paint disclosure, has he provided value to his clients? No. You should know the difference, right? Let's go back to the lead-based paint disclosure. This is one, by the way, $20,000 fine per incident, and the feds can audit up to 10 files, right? So, by the way, it's just shy of 20,000. It's like 19,000 and change. But roughly you're talking 200,000 bucks if you got audited and didn't have this. What about the lead-based paint pamphlet? Whose job is it to give them the lead-based paint pamphlet? We're pretty good at giving the lead-based paint disclosure, right? We get that done. What about the lead-based paint pamphlet? Are y'all turning that over? Because here's the thing, if we look at this, typically nobody knows if they've got lead-based paint. So they're marking, we don't know anything. We don't have any reports. But it says right here that we've attached a copy of the lead-based paint pamphlet to this document. And the seller signs saying that they've done this. And then the agent comes down here and signs and says, we've informed our seller of their obligations under this law, and we're aware of our responsibility to ensure compliance. Did we do it? We signed and said we did. Seller signed and said we did. Did we do it? We're looking in the file. Is the lead-based paint pamphlet in dot loop? Can we prove that we sent it over? Now, I just texted one of our attorneys. He's actually one of the lobbyists. He's the CEO for our local board. He functions as a lobbyist as well. He works together with the forms committee. And my proposal to them was, hey, can we rewrite this form so that we have a link to the lead-based paint pamphlet right in here? So we send over the lead-based paint disclosure with a clickable link that they can go and get it. Like, would that suffice? Would that comply with this rule? And he's like, hey, they thought it was a good idea. So he's going to, I asked him that about a month ago, if we could do that, when I heard about these audits that were going around. But guys, we should be aware of this, right? This lead-based paint pamphlet, we should be aware of it. Okay. So anyways, that was the one that I really wanted to talk about because that's new. So with this said, guys, we went over some scenarios today. I did mix it up a little bit from things that I've done in the past. We talked about how some of these scenarios directly affect you with current events that are going on. And here's the takeaway that I want you to have. Every single one of you should have in your calendar a repeating event. If you're experienced, it should be once a week for at least 30 minutes where you're studying your forms or state law. If you're a brand new agent, it should be every single day. At least 15 minutes every single day. If you can do more, 30 minutes would be great. But what you need to do is you start with your forms. Pull up your list of forms and think, do I know everything in this form? And you guys saw how those details mattered, right? Do I know the details? Lead-based paint disclosure. Yeah, I'm familiar with it. Are you? Every home prior to 78, this matters. Or does it include 78? Is it 78 and prior? Ask yourself those questions, right? Ask yourself those questions. Those details matter. This is where we provide value. This is where we are worth our money. Buyers agents, listing agents, we need to be creating this value for ourselves, and we need to be communicating this value. Right? Would it be nice when you sit down with a seller or a buyer and you say, you know what, one of the greatest values I provide is the knowledge of forms. I study the forms every day. I study the forms, I study state law. It's a recurring activity for me because the world's a scary place. Attorneys are thriving. Regular people, not so much. We get taken advantage of because we don't know any better. This is one of the ways I protect you. I personally would like that. I've had very savvy businessmen who have their own attorneys on staff, have forever. And they called me up over the craziness of the market over the last few years and said, I've got my own attorneys. I've never hired an agent, but on this deal, I want you to be involved because I can see the market turning and I want to make sure my paperwork is done perfectly. And I trust you for that. You're the only one I would trust. That's kind of cool, right? That's the reputation you want to have. All right. Our value is not in, well, and I just heard this in an interview last week. Like I find all my own stuff online. I don't even know why I'm paying that agent. That's not our value. Finding homes online, oh, here's a listing I found for you. Nah, they can do all that stuff themselves. All this other stuff that we've talked about today, they can't do it themselves. They don't have the resources. They don't have the knowledge. They don't even know where to start. And even if they did, they wouldn't do it. And to be quite honest, there's a good chunk of real estate agents that aren't doing it either. This is where you can shine. This is where you beat your competition. All right. Enough soapboxing for me today. Thank you guys for joining me. I hope this was valuable time spent. Please go to your calendars. If you don't have it in there right now, go to your calendars, put in a recurring activity every week. For me, it's state law. I know my forms pretty well, but every once in a while, even me, I'll get corrected by an agent. They're like, I'll do a training and they'll text me and say, by the way, didn't you know that form got updated last week? And I'm like, oh shit, I don't. And I'll pull it up and then I've got to retract and do all that stuff. Guys, it happens to the best of us. Be on guard, put it in as a recurring activity and live your life better. Thanks, you guys. Have a great week.
Thank you.